March 2007 decision by the U.S. District Court of Appeals in Washington against the SEC, which vacated the FPA's suit against the SEC regarding the Merrill Lynch rule, was sort of the one major point in this decades-long change and evolution regarding advice in the securities industry. The real issue goes back, really the roots are in the securities laws, both the securities laws of 1933 rather than 1934, which set up the regulatory structure for the brokerage industry, and the Investment Advisors Act of 1940, which set up the rules for the advice business. And by the 1990s, there was conflict in the rules and in the practice because of changes in the nature of advice. Up until about the 70s and 80s, the focus of the securities business had been providing transactions. Over time, transactions became less and less expensive to actually do, and the cost of them became apparent after 1975 and the rise of discounting and the entire role of what the advisor was to do. It wasn't just doing transactions, which became sort of ancillary to advice. The advice became more important, but the securities laws are written so that the advice is incidental to the transaction, and that became a problem. What was addressed in the late 90s by the Tully Commission, Dan Tully, the head of Merrill Lynch, looked at the issue of commissions. There were lots of charges of churning among brokerage firms. So the solution was to offer fee-based accounts and to encourage fee-based accounts. The problem was that advice being incidental to the transaction set up a legal stumbling block. Could brokerage firms set up fee-based accounts with providing advice as kind of the spice rather than the main dish, so to speak? So the SEC gave Merrill Lynch in 1999 an exemption saying, yes, you can do this. You can offer fee-based accounts, and it would be exempt from the rules requiring brokers to register as advisors. In 2005, the SEC said that's okay, through law, saying that they set up an administrative rule saying, yes, that exemption is okay. They called it the Merrill Lynch exemption, saying it's okay to provide advice in fee-based accounts as long as they were still brokerage accounts. So it's kind of circling the square in a sense. The 2007 decision by the appeals court in Washington vacated that rule and said, no, the SEC exceeded its authority and they couldn't make that a rule. So the question became, what is advice ancillary to the transaction, or is what advisors offering actually advice, and the transaction is ancillary to the advice? And we're still in that legal limbo today because no decision has been resolved. After the decision was vacated in 2007, things were left holding until Dodd-Frank, which was supposed to reconsider this whole issue of advice and whether advice is, should there be a uniform fiduciary standard for everybody. That's still up in the air. So we're still in this kind of legal limbo. There's no new Merrill Lynch rule, and brokerage firms are still offering fee-based accounts and having advisors wear two hats very often. One is a brokerage hat, one's an advisory hat. And we're still left in the position where most investors don't know what they're getting.